एक दो
Testing.
तीन चार पाँच छः.
Ready? Good.
Okay. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my partner. David, welcome.
Thanks so much, Michael. Always a pleasure to be here.
So what's up? Talk about some interesting subjects today.
Okay,
What's on
sounds
your
good.
mind?
Sounds good. Well, I think that one of the things we should definitely talk about, Michael, is in light of the fact that we've seen a very rapid escalation in the EB2 and the EB3 classifications in terms of the advancement of the priority dates. A lot of the recent questions that we're getting in our office from clients and also from some of our viewers has to do with the use of Section 106C under AC 21, and that is that when an individual is filing for adjustment of status when their priority date has become current, then of course they have the ability to utilize what's called mobility under AC 21. So what exactly does that mean? Well, what it means is that when an individual does a perm labor certification application, that at the end of the day, they don't actually have to go to work for the employer that did the original perm application, because it could be that many years later, after they originally did the labor certification, now they could be working for a different employer. So what is AC 21 Section 106C? Well, what it means essentially is that, let's say they did a perm labor certification application with Company A, and that perm application, of course, was approved by the U.S. Department of Labor. And then they've gone to step 2, which is that they filed the I-140 petition for the foreign national worker with the USCIS, and that case also has been approved. Well, what happens then is once they can file their adjustment of status application, then after 180 days, then the individual is able to move to a different employer in what's called the same or similar occupation. But they do have to prove that they're moving to a different employer in the same or similar occupation. And that's where there's a little subjectivity here. So when these priority dates become current and they can file their adjustment of status, after 180 days, they can move to a different employer. Now, then the first question, of course, that we get from our clients is, well, do we have to notify the CIS that we've moved to a different employer?
I do. Most of the times I do.
Yeah, the answer is yes, that generally
But they say
speaking.
even if somebody hasn't done it, it's not a big problem, but they say recommend that, and we always do that.
That's correct. That's correct, Michael. It's a best practice definitely to go forward and notify the USCIS in some way if you can. Oftentimes what ends up happening is when you file the adjustment of status application, you may receive what's called an RFE, a request for evidence. And if you do respond to the request for evidence, because in that request for evidence, what they might do is they may ask for payroll stubs to prove that you're still working for the organization that did your labor certification. So is that notification adequate?
What you're saying, there are other question also, that when they under this AC 21, they go and transfer to the other employer. At that point, they must still be in a valid status. In other words, in order to transfer from employer A, who did the labor certification and who still filed the I-140, and now they want to transfer, they must still be maintaining their valid status or employment with the employer A. So if they stopped working, for example,
well, remember that at this point in time, probably after the 180 days, after they filed the application for adjustment of status, in theory, they should have an employment authorization document, which would, right, so they should have an employment authorization document, which would allow them to go to the next place of employment. Let us say
that I'm going to in a different type way of questioning that thing. If the employer A who did the labor cert I-140 fires him, and then he waits 5-6 months down the road, finds another employer, and they wants to transfer. I think the requirement, he must do that when he's transferring right away, rather than waiting 6 months or a year and then trying to transfer. But by that time, there's already a problem. But 1 year ago, he never did that. He stays for a year before he transfers. He must transfer right away.
Well, I guess the idea is that the individual after 180 days gets a private interest, a private right.
But those 180 days he is still working. That's the point. Let me put it this way: those 180 days he is
Well, it should be.
Should be.
Should be. That would
should
be the idea.
Or should be even not working. The
But I don't-
employer A hasn't withdrawn the petition, or that is.
Well, that's the
continuing.
other thing. Yeah, the employer A should not have withdrawn the petition,
Correct.
of course. Yeah, because
Okay,
then,
so let's
then it
give an
becomes
example of
issue.
Mr. Patel.
Yeah.
August 2007. He had a labor certification with a priority date of 2004 or 5 or 6. You know what happened in August 2007? They made all the employment preference categories current.
Exactly.
So
So there was a
he
rapid
filed-
run on visas.
He filed an
Exactly.
I-140.
Yep.
Even EB3,
Mm-hmm.
even EB3, not only two, EB3. He filed an I-140, filed a 485 for himself, for wife and everything, and got a permission to work and stay, and has been working, or that case has been continuing for some period of time. Now, 3 years, 4 years down the road, or whatever period down the road, that employer he is not comfortable with, or he gets a better job offer, doesn't mean different but same.
Right. Same or similar
there's
occupation.
a reason to move. He's living in New Jersey, and but his family is there in Dallas, Texas. He wants to move to Dallas. Question is, how does he do that? Some people say, do I have to? The new employer has to do a new labor certification, has to do a new I-140, and the answer to what you are explaining is no. You don't need a new labor certification from the new employer.
Exactly.
You don't need a no I-140 from the second employer. All he needs a letter from the new employer which explains what kind of job it is, the salary it is, and he's now, he already has a valid EAD anyway.
So he could take
So under
advantage
that
of this
EAD,
mobility
he's
provision.
transferring and notifying to the immigration service, and then the case will continue.
Exactly.
Correct?
Exactly.
No.
Now, it's likely that, at least in terms of the general practice, that these cases may be noticed for an interview at the district office, in which case, of course, what we would do is we would put together an appropriate package for our clients or someone with an issue like this to take with them to the interview, which clearly demonstrates that the position, the new position they've taken, is in the same or similar occupation, because that's a subjective determination. So you have to help the officer understand that it's same or similar occupation.
But if everything
For
is
example,
kosher,
right, but for
everything is kosher, shouldn't be a problem.
exactly, but for example, you may have an individual, let's say, who did a labor certification application with company A, and then later on decide to go into business for himself. So even though, let's say, he originally did the job as a consulting IT consultant, now has his own IT consulting company. Is that same or similar occupation? Well, it sure is same or similar occupation. It just happens to be now that the individual is going to be in their own business, and they're going to be paid maybe a different, so there's going to be a different pay
Shouldn't
level.
there still be an employer-employee relationship? There has to be an employer.
Of course, of course.
There's a company, that
Yeah.
company in which he has entered, I don't know, that may be a little bit of.
No,
concerns,
self-employment's no problem. And also, what we've also noticed, which is a really nice thing for Section 106C, is that it gives the employer also, if let's say the employee is still with employer A, and let's say there's a differential in the wage, it gives the employer the opportunity to push the employee into a different position using Section 106C mobility, and to, let's say, lower the wage so that they don't have to pay, let's say, a very high wage that the U.S. Department of Labor was reporting out when the perm labor certification was
The
originally
most
done.
important thing is that it has to be a same or a similar job. So the
Occupation, right, exactly.
person filed as a restaurant cook,
Yeah.
right? And now he's getting a job in a grocery store as a salesperson. That's a no-no.
Well,
It's a
that's
different-
interesting, because there's a little play. Because let's say he's getting a job in a grocery store, but there are a lot of positions in grocery stores where the people are taking care of food. So if they were taking care of food as a cook, and then they're taking care of food in a grocery store,
don't know.
I would argue that it's same or similar
You
occupation.
are stretching a little bit more, but
Yeah,
it's
but this
okay.
is why the clients hire me, because I try to be creative with their cases,
This
Michael,
job
right?
is cooking the food, and there is not cooking the food there. That's what.
Well, some of the people stand behind, things where they're cooking the food in the
Anyway,
grocery
but the
store.
law says
But
very
I understand
clearly,
your point. I
Same
know what
or
you're-
similar job.
Exactly.
Now, one other thing is people have a question about the jurisdiction. In other words, the employer A is located in New York. Some people think, yes, I can use the AC-21
AC-21,
only
yeah.
if the second employer is also in New York. That is not the case.
That's right. It
No
has to do with
geographical
geographical
limits.
location.
No, any
Sure.
place in the USA.
Exactly.
Yeah.
Exactly. So AC-21 is a really nice methodology that can be utilized by employees and sometimes even by the employer, because you're going to have nuances and differentials from the original labor certification to the job that the person's taking. So the question becomes, can you still use that original labor certification? And so again, the most important thing to do is to reach out for a qualified business immigration lawyer who would be able to explain to you the nuances of Section 106C and how to utilize them.
I have one more question. What happens when the person is permitted to have a joint filing of a I-140 and a 485? He filed it. For some reason, the I-140 is still pending for a year or more. Of course, 180 days have passed. I think it's not advisable for that person to go under AC-21 until the I-140 is approved. The problem is that he does transfer and that I-140 is denied. That becomes a big problem.
That's exactly right, Michael.
So we recommend people that
we wait. Yeah, I think the best practice, of course, is to wait. That was something that was being done many years ago, where the I-140 and the I-485 were being filed together, and people were trying to take advantage of AC-21, Section 106C, where the I-140 was not approved.
Exactly.
But now I think it's pretty clear in the releases that have been put out by the USCIS that the I-140 has to be approved. Yes. That's right. Yeah, no, it's excellent.
The person got his EAD, wife got EAD. The 485 that is filed by you and the family members continues. You don't have to fill up any more forms. Sometimes they say just update the biodata form. But there's no new labor cert, there's no new I-140, there's no new 485, there's no additional immigration fees for doing that. That's correct.
Exactly. That's right. And so it's really important for you to keep an eye on when you might be able to take advantage of this provision of the law, because it gives you the opportunity to have a lot of flexibility with the original labor certification that was filed for you.
Somebody could look in that, oh, David and Michael told this way, so it's a simple black and white and I'll just do it. I would say there is still always certain areas of any kind of work that is done in immigration that could, if not properly followed, or an error is made, that could cause big problems. Maybe a small problem in terms of a person will say, oh, this is something very small, what's the big deal? For this little question, do I have to go to a lawyer? I'll do it myself, fine. If you know what you're doing, it's fine. But it's always a good idea at least to consult a good immigration lawyer to see whether there's a right way he's doing, the path is doing, does he need an assistance of a law firm to deal with it?
Right.
Because there are two employers talking also sometimes. Employer is going from, he may have some questions. Employer that he's going to, he may also have some questions. I'm hiring him based upon this EAD, shall I do that? Is it okay, Mr. Nachman, or what? So this is the question. Basically, the good advice is that do it, find the right path, and do the right things in handling any kind of immigration matter. Actually.
Exactly, Michael. It's the message that we've been conveying to our viewers for years now, and that is make sure that whatever you do, go to a qualified immigration professional, ask the questions, and get the right answers.
What's the story on the CSPA, the Child Status Protection Act? I don't think that affects, because they are looking at the priority date remains the same. Because people have this question also. By transferring, is my priority date going away? No. The priority date of the first case, the labor cert and I-140, continues to be.
That's right.
And therefore, the CSPA calculation that is made is based upon that part.
It's based upon the approved I-140, and it continues to be the approved I-140. Exactly. So nothing has changed in that realm. Yeah. So, Michael, I know that you wanted to talk about administrative processing, and I have to say that I've received recently numerous calls about administrative processing.
Wait.
Specifically,
what we are talking about, and we're talking basically to clarify to the viewers.
Yeah.
We are talking now going away from immigration, we are going to the American consulates.
Correct.
That's people go and apply for different kind of visas. Could be a visitor visa, student visa, H1 visa, J1 visa, immigrant visa, any kind of visa application they are making. 2 or 3 things happen. Consular officer, everything's fine, perfect, no question. The same day the visa is issued when they are going for interview. Then there are some cases where consul is lacking something, or there is need for investigation or a verification, which happens very frequently. In other words, a couple of times, very rarely, they invited him for interview when the visa numbers were not even available or had retrogressed. Exactly. The consul says, sorry, I can't do anything. Unfortunately, the visa numbers have gone back. We have to wait until the visa numbers become available. Again, it happened a lot in F4 category once that we did. Or if the council has fraudulent, maybe that marriage is a fraud. Maybe that this child he's adding on is really not their child. Maybe in the labor certification he's claiming that he was a manager of Dunkin' Donut in Nadia, that at that time 10 years ago that there were no Dunkin' Donuts there.
Could be any number of
Any
issues.
number of,
Yeah.
I mean, I had a Gujarati lady, I remember this, working in an Indian restaurant in India, and she was making different kind of food, including beef curry. Come on, in a Gujarati restaurant in Gujarat, beef curry, you must be kidding. I told her, and basically it was, this case came to me just for a second opinion. I say it's dangerous, but you go there anyway. We have to go for interview now. At this stage, you are luck.
They're very open-minded Gujaratis, I guess. Right?
Yeah, but I'm saying these kind of issues when they come, the American consul probably did not even look at that or did not think about that. So it was good luck for her. It worked out. But those kind of cases where they need to verify the facts, where they do conduct investigation, right. There's also a question of security clearance sometimes. Everything's fine, but it hits. That means they cannot issue the visa until they get a clearance from FBI and other agencies. So what do? They keep the case pending. Many of these reasons, Section 221G, and all they will say admin processing. And people say, what does that mean? I say, could be any one of these things. I don't know. Sometimes we looking into the papers, you and me, we get some kind of feeling where this problem is coming from. So that's one of the issues. I think there's a lot, this particular subject, there are a lot of things we can talk about, how to be careful, how to resolve these issues and all that. Today's program, we have to come and end. We are finished with the time that we have for today. And David, thank you very much for coming on the program.
Thanks so much, Michael.
Keep watching us every Saturday and Sunday. Information like what David gave to you today, AC21 and 221G and many other issues we'll bring to you from time to time. Thank you very much and goodbye.
Thanks for being with us. Bye now.